All right, I just want to say good afternoon to everyone. Let's go ahead and set forth our appearances. We'll start first with the plaintiffs and we'll move to the defense.
Your Honor, Will Kemp, Eric Pepperman, Brianna, Switzler, and Teddy Parker for plaintiffs.
Joel Odou and Matthew Kaufmann on behalf of the Real Water defendants.
Eric Freeman and Eric Storm on behalf of Real Water as well.
All right. So where did we leave off?
Looking at 537.
All right. And that would be Affinity Lifestyles motion and eliminate to pre-admit Real Water business records. Is that correct?
Yes, Your Honor. Mr. Kaufmann will be handling this one on our behalf via Zoom.
Good afternoon, Your Honor.
Good afternoon.
Matthew Kaufmann on behalf of the Real Water defendants. I'll be really quick. Your Honor's made a, he reads everything and knows the arguments here. What we're seeking to do over the course of the last couple of trials, plaintiffs have elicited testimony from certain witnesses that Real Water did not have written protocols.
Didn't they have what? What didn't they have?
Written protocols. I apologize, Your Honor. I'm on a new computer setup. And we would like to pre-admit some of those written protocols. Many of the documents we're seeking to pre-admit were signed by a man named Jeff Desitel, who was the retired Army sergeant who testified during the Gallagher trial, and he has also testified during the two subsequent trials. We believe there's a good faith basis for pre-admission. We believe the documents are relevant because plaintiffs have made a point of talking about the lack of SOPs. In particular, Mr. Desitel has talked about the lack of standard operating procedures and written documents at Real Water. And on those grounds, we believe these documents should be pre-admitted, Your Honor. Thank you.
And for the record specifically, what do the documents at issue set forth?
So the documents are a mix of a couple of things. For example, we have a list of all the Real Water SOPs. We have a new hire check. We have the kind of documents that Mr. Desitel would have come across in his role as director of the line. For example, checklists related to the production line, to cleaning of the production line, as well as employment documents for other production line workers that were signed by Mr. Desitel. And these documents, for example, would be like, did you show them this document about, cleaning up after yourself? Yes. And it was signed by both the worker and Mr. Desitel. So we believe those all go towards Real Water's use of documentation, even though at the time, we do concede that at the time of the FDA inspection, the documentation was not available, but that doesn't mean that it necessarily did not exist.
Okay. Anything else, sir?
Not at this time, Your Honor.
Mr. Pepperman, yes.
I think it's important to keep in mind that the call of the motion here, which is request to pre-admit certain documents that counsel did not spend much time identifying or going through.
Well, that's why I asked the question, what documents are we talking about?
Correct, Your Honor. And so the pre-admission is the narrow issue before the court. And we know that authentication of a document is a condition precedent to any admissibility. That's NRS 52.015. And we cited in our opposition the pre-SB by case, which reversed the verdict because of errors in admitting documents that had not been authenticated, and stating that authentication requires a witness with personal knowledge who can testify as to how, when, and in what manner the document was created or used. That's what we don't have, and with respect to any of the, vague, broad references to documents, none of them have been properly authenticated. So you have not been presented with any witness testimony or affidavit or declaration of a witness with personal knowledge regarding how, when, and what purpose these documents were created. Most of the documents are undated. There's no information as to whether they have been updated, when they were in use, when they were applicable, what the use was for. The first problem with granting pre-admission of these documents is there's just a broad reference to large categories of documents, but two, there's no foundational testimony cited anywhere in the record that any of these documents or checklists or whatever they're described as are accurate, when they were in use, or anything else to sufficiently establish that these were business records or otherwise admissible under any hearsay exception. And we also note in the opposition that on page 4 of our opposition, that these same types of documents, these SOPs, were asked about by the FDA during their inspection and investigation, and that the FDA did not receive any original copies or documents and question the documents that they were provided. The FDA questioned these documents' validity and the reason why the actual underlying documents weren't produced. And that's in the EIR report, which we cite as exhibit 1 to the opposition.
And when you say SOP, you're talking about standard operating procedures?
Yes.
And what does that mean?
Well, that's a good question, Your Honor, because there's various standard operating procedures, some of which may be relevant to the issues in this case, some of which are not, which is what I was going to get to next. Was Real Water has not established the relevance of any of these documents. I think it shows the exhibit QQ, which is one category of documents that they seek to pre-admit. This is a list of that refers to SOPs, but most, if not all, of these SOPs aren't actually before the court, and they're not seeking to pre-admit the actual SOPs themselves, just these checklists, as if to say, look, see, we have SOPs, which we don't know whether that's true or not, because they haven't produced any of these documents, or at least they're not before the court or attached to their motion, or they're not seeking admission of the actual SOPs themselves. Certainly from the list, we can see, and through some of the other documents that they do seek to pre-admit, many of these SOPs, assuming they exist, are totally irrelevant in this case. Any SOP regarding employee belongings, for example, or patrol inspection forms or protocols, those really aren't. They have not established how any of that would be relevant in this case. Most importantly, Your Honor, there's nothing in these SOPs or documents or checklists that they seek to pre-admit that have anything to do with the concentrate making process, which is the pertinent step where hydrazine was created. And again, importantly, we cite on Exhibit 5, the FDA EIR report, the Establishment Inspection Report, where the FDA specifically requested documents and SOPs related to the manufacturing process, and specifically the concentrate making process, and those documents were never produced. Not only have they not established—
I just want to make sure I'm clear. When you say never produced, that would be to both the FDA and also in this case?
To the FDA, certainly, and to my knowledge, I haven't seen any SOPs or documents pertaining to the concentrate manufacturing process. If they do exist, and I just am not aware of them, they're not cited in the motion, and they're not the subject of their request to pre-admit any of those documents. So if they do exist, they're not seeking to pre-admit them, and the documents they are seeking to pre-admit aren't relevant because they have nothing to do with the concentrate making process. And it would be it's not only have they not established any relevance for any of these documents they've identified, but it would be unfairly prejudicial to pre-admit these documents and let them wave around, checklists about SOPs that they supposedly have that haven't provided, and make it seem like they have SOPs regarding the manufacturing process, the concentrate making process, or anything that's relevant to any issue in this case, without actually producing those documents and laying the proper foundation for those documents. The other documents that they cite are, and seek to pre-admit their employment and hiring and training checklists for, I think, one individual who is not identified as a witness in the case. We've never heard of this person. We don't know what his role was. We don't know what any of these training checklist documents have to do with any issue in this case. There's no testimony about the documents or what they purport to be. There's no foundation for them whatsoever. There are a few documents that are signed by Mr. Desitel, but again, there's no effort to establish how these are relevant or any testimony from Mr. Desitel or any other employee from Real Water establishing the proper foundation for any of these documents for pre-admission purposes. Now, if Mr. Desitel, when Mr. Desitel testifies, if something he says makes one of these documents relevant and he can lay the proper foundation for it, nothing prevents Real Water from seeking to admit the documents at that time. But for pre-admission purposes, they have done nothing to establish the basic requirements for admissibility, and we'd ask that the motion be denied.
All right. Okay, let's hear the reply.
I'll just be brief, Your Honor. I'm gonna hit on a couple of main points. One, they're relevant because they're directly responding to plaintiff's expert, Dr. Hutt, and testimony plaintiffs have elicited repeatedly from Jeff Desitel that there was no training done, that there was nothing done, that Real Water was completely defunct. Desitel, and the reason, for example, Eric mentioned the training documents. The training documents are attached as exhibit. It's on for Mr. Fleming, and Mr. Washington. The point is not necessarily that about Mr. Fleming and Mr. Washington. It's about the fact that they were signed by Jeff Desitel, who trained them. That's the importance of these documents. As far as the SOPs being produced, the SOPs were produced to the other parties in this litigation. As a matter of fact, there are multiple sets of SOPs produced over the course of this litigation. I once again go back to the fact that the FDA.ERI document just says that they were not produced when they inspected the facility on 2 discrete days. It doesn't say that the documents didn't exist, period. It was a failure to produce at the time. It's very similar to, I don't know if you remember the NSF audit that's also an issue. Again, in that, there was problems with documents being produced at the time that were later corrected. I honestly think a lot of plaintiffs' arguments here are more straw men than anything else, Your Honor. Finally, you know what? That's all I got, Your Honor. After that, I'm ready to rest on the briefs.
Yeah, I mean, ultimately, as far as the document's concerned, first and foremost, we have to establish their relevance. Secondly, we have to establish what were the business practices as it relates to the use of these documents. And we don't know that. And that's really important when you pre-admit a document. And in a general sense, pre-admission of documents are generally limited to things that are really not in controversy, from a foundational perspective and also factual. Like, for example, sometimes in tort cases, you see pre-admissions of medical records. And we know that's what they treated with, right? And you can pre-admit those. And sometimes you might see photographs of an accident scene. those might get pre-admitted, or and it could be a motor vehicle accident, it can be a trip and fall on a stairway. And things like that, but it doesn't appear to me, number one, I guess these are being contested. Yes, they've been admitted during the course and scope of discovery, but these are the issues I want to address when they're offered, because I'm not saying they can't be offered. Number one, they have to be relevant to the issues in this case. Number two, how were they used? What were the business practices? Were they really used? Because you can have procedures and policies in place and never use them. They could be sitting in a cupboard somewhere collecting dust. I need a foundation for usage for every employee. And that's why I'm going to deny it without prejudice. I'm not saying you can't use it, but there's a difference between using it and laying the foundation for the document. And I do understand there might be a business exception under hearsay, but still you have to establish and lay that foundation. That's all I'm saying. I'm not saying you can't use them. We just can't pre-admit them until the foundation's laid. And then you can use them potentially. And this is important. I got to know what they are with a little more detail so I can determine the relevancy. Okay, let's go on to the next one.
This will be docket number 542. It's Real Water's motion for summary judgment on Plaintiff Henry's lost wage claims.
There was no opposition on this one.
That's correct, Your Honor.
Okay. In light of no opposition, that will be granted.
Next up is docket 551. Real Water's motion for summary judgment on all claims of plaintiffs Lorenzo Muniz and Stephen Watkins.
Good afternoon, Your Honor.
Good afternoon.
This motion for summary judgment is against the two plaintiffs, Muniz and Watkins. There's no dispute that plaintiff's cause of action has a 2-year statute of limitation. The statute of limitation begins to run when the plaintiffs are put on notice that they have a claim. They don't need to know all of the facts. They don't need to know even all the precise legal theories. They merely need a general belief that someone's negligence may have caused them an injury. I believe it's the Wynn case that uses the phrase generally aware that they have a claim. And in this case, both Mr. Muniz and Mr. Watkins knew Real Water caused their injuries by June of 2018. Watkins didn't file until March of 2021, and Muniz didn't file until July of 2022, both after the 2-year statute of limitations ran. And we know this because it's their own sworn testimony. Muniz testified that they knew it was the Real Water. The whole family knew it. They stopped drinking the water after Mr. Muniz and his family began to get sick. They canceled the Real Water subscription that they had. They all knew and all agreed that it was the Real Water that was causing these injuries and illnesses in their family. Mr. Watkins knew as well. His doctor told him, stop drinking alkaline water. He testified that the doctor specifically told him, stop drinking Real Water. His wife even sent an email to Real Water saying that the doctors told them that Real Water was making them sick. This was all in June of 2018. We're not here to argue that, well, these two plaintiffs reasonably should have discovered this. We're not arguing that if they would have used due diligence, they could have discovered it. They both knew, and they testified clearly that they knew, they were told. Their families all agreed it was Real Water that made them sick, and they didn't file until after the statute ran. Plaintiff's argument in opposition focuses on when did Real Water know? When did others know? It doesn't matter what Real Water and when others knew. It's when these plaintiffs knew an injury was caused by real water. They also argued that, well, they didn't know, well, it was hydrazine until 2021. You don't need to know it's hydrazine. You don't need to know all the particular facts. You don't need to know all the legal theories. You just have to have knowledge, be generally aware that someone's negligence caused your injury. And so,
Remember, this is not a negligence case. This is a products liability case, and there's a difference there.
it's still notice and when you became aware, and both of them testified to that knowledge. They knew that real water caused their injuries and so again, they had knowledge that this was caused by their injuries. It's not an issue of due diligence. It's not an issue of reasonable investigation to know or to learn. It's they knew, and they knew by June of 2018, and they did not file until after the statute ran.
And specifically, we're talking about chapter 11-190. Is that it, or what statute are we relying upon?
I don't have that statute right here in front of me, but that I will say generally, I think that's correct.
And the reason I'm asking that, what specific provision?
I apologize, Your Honor. I don't have that here in front of me. I can't answer your question.
The only reason I ask that, I think I have to do a statutory analysis. Right, and make sure I'm clear in the language.
The Wynn versus Sunrise Hospital case states the statute of limitation begins to run when a plaintiff is put on inquiry notice, when he should have known the facts that would lead to an ordinary prudent person to investigate the matter further. And by June of 2018, they had much more than inquiry notice. They had their own knowledge, their family's knowledge, their medical provider's knowledge, all told them that it was the real water that was making them sick. I'll save the rest of my time for rebuttal. Thank you.
Okay.
Good afternoon, Your Honor. I think the points that you raised are quite valid, and I think it, especially as it relates to the difference between negligence and strict product liability where we're here today. I also just want to take a quick step back. They're asking for a summary judgment here on two laymen when saying that there's no dispute of material facts. Real water cannot meet the standard and their motion needs to be denied. If we pull up Shane, our opposition on page 5, the real water defendants have sought summary judgment as to Steve Watkins and Lorenzo Muniz, absurdly contending that these laymen needed to know or should have known that hydrazine or real water or a toxin in real water made them sick in 2018, despite the fact real water defendants didn't know and have stated actually, quote, plaintiffs could not have possibly learned that hydrazine caused their illnesses until 2021 when the FDA tested hydrazine, unquote. The entirety of their motion is completely belied by their own assertions that plaintiffs should have reasonably discovered the facts or could not have reasonably discovered the facts until at least March of 2021, when the federal government did their investigation, real water recalled, and hydrazine was found. In November, that's when 2021, that's when the 5 children went up to Utah and this whole thing started. It was not until March 16th of 2021 that the Southern Nevada Health District issued a press release linking real water to acute liver failure and non-viral hepatitis. This is when plaintiffs testified that they had notice of their claims. They testified they didn't know until the FDA and the epidemiological connections between everything happened in order to put them on notice of their claims that there was actually a toxin in real water that caused their injuries. And there are numerous assertions that real water defendants have made in their briefing to juries and even to your honor, which completely it stops them from making the arguments that they're making today. If we look, and I know Shane's going to kind of put these on the screen as well, they're included on page 5. The real water defendants told a jury no one knew what hydrazine was. No one knew what it was until the FDA found it. So no one includes the plaintiffs. They didn't know as well. There's not a listing on the product bottle saying, hey, it contains hydrazine. You might have liver failure from this. Specifically as to Steve Watkins, the real water previously argued in front of this court, he didn't learn that real water made him sick until after it was on the news. And now they're saying the complete opposite. The real water defendants also sought differences between alkaline water, which is what they just said previously today, and how that's different than real water, which contained hydrazine. And again, another quote that they said is he, referring specifically to Steve Watkins, was not told that hydrazine caused his symptoms and could not have possibly learned hydrazine caused his illness until 2021 when the FDA tested hydrazine. That is what the real water defendants have said previously as to Steve Watkins and the plaintiffs in this case. They've continuously argued before the jury and this court that the plaintiffs were not on notice until the recall in 2021. Yet now they're suggesting the exact opposite, suggesting it is undisputed and irrefutable that they were on notice and they knew that these two laymen in 2018, 3 years before anyone at Real Water supposedly knew, 3 years before the FDA knew, 3 years before Southern Nevada Health District. And real water defendants, they're the manufacturers themselves. They're the ones who knew of this secret concentrate process. They knew of the weird Russian titanium tubes. They knew that not all the products were listed on their ingredient list, as there's different ingredients depending on what label you're looking at. And yet they're saying that they were completely unaware that their product contained hydrazine, but want to impute greater knowledge onto lay people who just purchased their product. It cannot be both ways. They can't say one thing and another. That's judicial estoppel. In fact, the real water defendant's motion should be entirely disregarded because it is the essence of judicial estoppel here, and their motion should be denied on that fact alone. Now, on top of this, even if you ignore the complete swapping of ideas whenever it supports their own position, real water can also not demonstrate that summary judgment is on that they're not disputed issues of fact on this. In Nevada, the diligent discovery rule applies to product defect actions, which states that the statute of limitations does not begin to run until the plaintiff knows the facts constituting all essential elements of his cause of action, including causation. You know, they admit that hydrazine wasn't found until 2021. The epidemiological studies didn't happen until 2021. And so that's when they knew about causation. That's when they knew about the essential element of their causes of action. Peterson versus Bruin provides the rationale behind this rule. The policies served by the statute of limitations do not outweigh the equities reflected in the proposition that plaintiffs should not be foreclosed from judicial remedies before they know that they have been injured and can discover the cause of their injuries. In fact, less than a month ago, the Nevada Supreme Court unequivocally confirmed the longstanding precedent and policy behind this in Atkins versus Union Pacific Railroad Company. And that was just decided August 15th of 2024. And there, the plaintiffs had argued that they weren't aware about information on toxins at the Clark County Government Center and that it was concealed, which hindered their ability to file timely claims. The Nevada Supreme Court overruled the district court's dismissal, determining that there were issues of fact precluding dismissal of their case. It's analogous here because plaintiffs had no way of knowing in 2018 that there was rocket fuel in real water that made them sick. Real water was continuing to be sold, assuring plaintiffs and the public that this product was safe and safe to consume. It was not until the FDA investigation, the Southern Nevada Health District press release, and the ultimate recall of the product where plaintiffs became aware of the facts supporting their cause of action. And this is what they've testified to. Lorenzo said it wasn't until he saw a billboard that had information on it till he really connected the dots and knew that his father, who's the one that stopped Real Water, might have known something before he did. But it wasn't until 2021 when all this news came about, the same things that Real Water has previously said about all the plaintiffs. At a minimum, it's clear that
And the plaintiff's injuries, these two specific plaintiffs, what are they again, Mr.?
Mr.
Muniz?
Watkins and Mr. Muniz.
No, I know who they are.
Oh.
What are their injuries?
So they both had very similar injuries to the rest of them. Lorenzo Muniz was actually life flighted to a hospital in Southern California where he had acute liver failure. He was on the transplant list until he started drinking the hospital water and got better. And so then he was transferred back and released. Watkins spent actually several days, I think 5 to 7, are my best recollection, in the hospital as well with liver injuries. So it's both specific to liver injuries, something no one would connect to bottled water until the FDA and Southern Nevada Health District did in 2021. And so I think really what comes down here is, even at base, taking aside the estoppel issues, is there's clear issues of fact that need to be addressed and resolved by the jury. And
And I have a question.
Uh-huh.
This is from a memory perspective. And it's been a long time, but it's my recollection. I think that what started the ball rolling was the neonatal care unit in Salt Lake City. Is that what
Correct.
started
So
the whole thing?
there were 5 babies here
Right.
between the end of November and early December that were transported to Primary Children's Hospital in Utah. There, Dr. Guthrie kind of pointed the fingers around and said, wait, why are all these kids from Las Vegas getting acute liver failure, which is a rare disease, and said something must be going on. Forwarded it to the CDC. The CDC started investigating all the families. The families only had one thing in common, and that was Real Water. And that's kind of what sparked the government investigation. That is what sparked the FDA conducting samples. And that's ultimately what led the Southern Nevada Health District to issuing a press release saying, warning, Real Water is linked to acute liver hepatitis. And that was not until March 16th of 2021. So, and what the case law says clearly in Nevada is issues under the discovery rule are issues of fact for the jury to determine. And so Real Water suggests, they cite to the Wynn case, which again is medical malpractice, which is different here.
Well, every case is different. For
Correct.
example, this is a products liability
Mhm.
case involving the plaintiffs ingested or drunk real water. That's a much different scenario than a car wreck.
Correct.
When you get in a car wreck and you suffer injury, immediately somebody ran a red light and they plowed into you. And you're being transported to UMC, for example. That's a different scenario than ingesting real water. The family gets sick, and here's the real kicker. I mean, you have to know. For example, did you know that the real water contained hydrogen?
And they had no way of knowing that until the FDA tested it and found it in 2021. And we even, at best, they started knowing about their injuries in March of 2021, when there's the epidemiological results kind of from the FDA putting out these warnings. But the hydrazine consuming, and the plaintiffs didn't really even know that the causal component to their injuries was hydrazine until the FDA found it in the samples that were taken at that time. So there was no way for any of the plaintiffs, lay people who had no understanding or knowledge into anything in the manufacturing processes and the secret concentrate or anything like that of Real Water, there was no way for them to know beforehand that hydrazine and rocket fuel is what caused their liver failure. There's no way, and it's laughable to think that there's any assertion otherwise, especially when Real Water defendants themselves have continuously argued to the jury that they didn't even know. So, and like I said, they cite to the Wynn case. The Wynn case says that you can only determine this issue on summary judgment if there is irrefutable evidence of notice.
Car wreck.
Exactly. We do not have here, and the real water defendants have not shown in any way, shape, or form that there is irrefutable evidence that Steve Watkins and Lorenzo Muniz knew or should have known in June of 2018 that rocket fuel in the real water caused their liver injuries. There's no way to know that. And when it took him hiring an attorney and to have medical records that explicitly provided that there was medical malpractice that occurred in order for the court to say that's when he finally had, there was irrefutable evidence. We don't have that here, especially when taking into effect the prior assertions and arguments that Real Water has said before this court and juries. Nowhere in the motion do the Real Water defendants make any argument that they knew or should have known as to all elements of their claim, especially including hydrazine consumption. Real Water previously asserted hydrazine was not found until 2021. Watkins and Muniz did not have access to manufacturing records. They had no knowledge as to the secret concentrate, an accurate ingredient list, or any other information to know that Real Water was contaminated with toxin or hydrazine before they learned about the recall in 2021. And that's what they've testified to. At best, even taking aside all the issues that we've raised herein, this is an issue of fact for the jury to determine, not an issue for summary judgment. And so, court's indulgence. And I just, so the plaintiffs would respectfully request that the court deny this motion for summary judgment as they have not met their burden to demonstrate otherwise.
Okay, thank you, ma'am. And we'll hear from the reply.
I just want to make a couple quick points. Their argument was focused on when did Real Water have notice? When did the FDA get test results? When did other plaintiffs who went to hospitals know? That doesn't matter. What it matters is these two plaintiffs, when they had knowledge, and they didn't need to know it was hydrazine. They didn't need to have the FDA test results. They only needed to be generally aware that a product caused them injury. And in this case, both of them testified that they had that knowledge. Their testimony is cited in the briefs and about their knowledge. And on that, I'll rest on the briefs.
And when you say they're cited in the briefs, what do you mean by that, sir?
Their testimony is cited in the motion.
I have it right here in front of me. I just want to make sure I can look at that.
It's exhibit A and B. A is Muniz, B is Watkins. It's their sworn testimony.
And what do they say?
I'm sorry, Your Honor.
What do they say?
They testified about after their family got sick, about attributing it to Real Water, stopped drinking Real Water. No one in the family drank it anymore. They canceled their subscription. Because they knew and they all believed that it was the Real Water that was causing their illness. Same thing with Watkins. His own doctor told him, told him and his wife sent an email to Real Water saying, hey, the doctor said the water's making made my husband sick.
At that time, did they know it contained hydrazine?
I don't think anyone did. And I really do not think they did. But that's not the point. The point is that they knew something in the product made them ill.
Well, the only reason I say that, and that's really an important point, in that there would be a difference between having potentially a stomach ache versus exposure to hydrazine, which is essentially used for rocket fuel. And there's a big difference between the type of injury you could sustain from hydrazine versus, say, food poisoning, for example. And that's probably the best example I can give you. There's a real big difference. And I feel that it's important, especially in a products case, because that's different from a quote medical malpractice case, depending on the case. So for example, in wrongful death, no matter what statute starts and runs when you dies, and everything's done differently. But I just feel that in a products case, they had to know exactly what they were exposed to, and that would be hydrazine, and because that, from a consumer expectation perspective, right? We use the consumer expectation test in defective products. No one would expect hydrazine in a bottled water product. I mean, it really comes down to that. And unfortunately, it happened. And I don't mind saying it. I do think it's a question of fact for the jury. And I think they have to assess specifically what was known to trigger the statute of limitations. Because there's a distinct difference between, for example, food poisoning case versus hydrazine. Hydrazine was unexpected. I realize was something that no one knew, but nonetheless, when you start a separate and distinct and new water manufacturing process using titanium rods from Russia, maybe you should kind of get I mean, before you put that on the product, you should send it down to a lab and have them do a full whatever you would do to find out anything and everything that potentially could be contained in the water.
For $100.
Yeah, but I mean, I'm just saying that that's a different animal. It really and truly is, because I don't think anybody was using titanium tubes from Russia as part of their manufacturing process when it comes to bottled water product. And that's why, I mean, this is a unique case. It really and truly is. It's
So plaintiffs will prepare that order?
yes, they can prepare that. That's what I really like about him. He bottom lines it every time. He does.
Don't get lost.
No.
You know, we were enjoying the conversation. I was adding that.
But I think it was important.
Yeah, you're giving.
Yeah. But see,
I'm just writing it down.
and the reason why I made comments, gentlemen, I don't mind telling you this, I think it's important for the Supreme Court to say, look, what was Judge Williams thinking about when he made this decision, right?
You're right.
And they do tell me I make good records.
I would agree.
They do, and that's really important, right? I just don't want to say denied, granted, next one, right?
No, I'm sure they'll prepare a good order.
That's,
Next up is docket 559. It's this.
and that's plaintiffs. Oh, docket 550, is this a plaintiff's motion?
Yeah, it's
Yep,
plaintiff's
same
motion.
Okay.
summary judgment number 1.
As to claims for strict products liability against defendant in real water. And that real water defendant sold an adulterated product.
Did we skip 552?
Is it on the list?
552 is liquor.
Oh,
Yeah.
okay.
Yeah.
All right. Apologize.
Okay. Let's move on. Who has that one from the plaintiff's perspective?
That's the Gray Maynard motion, right?
Yeah, this is plaintiff's motion number 1.
Okay.
You know, I don't know if this one has to be argued really, only because I think effectively we've already agreed to part of it. It's a defective product. The motion reads, I'll just read it. It says plaintiff, wait a minute, I got plaintiff's motion summary judgment number 2. It said number 1.
Yeah, Judge, what's
I
that?
got number 2.
So
You wanna-
is this number 532 we're doing?
Let's make sure we're on the same page.
59.
559.
Okay.
Is that number 2 or number 1?
That's number 1.
Number one.
And we're working on a stipulation that might
Yeah, let's
resolve
skip
this.
that one.
So why, if
Let's
the
skip
court
that
would
one.
indulge us, we might.
I'm
be
gonna
able to
let you
resolve
do this because I thought this one was pretty much resolved when I
Me-
took a
me-
look
I
at it
thought-
based upon the prior litigation.
Me too.
Let's skip that
So
one.
is
We'll skip it.
stipulation forthcoming or?
If we could put this over, we have one other that is already put over. I think the parties will resolve this in a day or two at the worst.
Okay.
Prepare a stip in order.
We will, Your Honor. So we're working on that.
What's next?
Actually, it's a larger step in order. It'll
Oh, I
move the
understand.
case along further too.
Okay, so next will be docket number 543, AffinityLifestyles.com. And Real Water's motion for summary judgment on Plaintiff Maynard's loss of wage claims.
You wanna do that one or not do that one?
Which one?
Want to do that one or not do that one? Do that one anyway, you want?
I mean, we have an opposition to it.
This is, I'm sorry, is this the Gray Maynard one? I didn't hear.
This is the Great Mayor.
Yeah,
We could, let's see. Yeah, I don't think our stipulation would take care of this one. I think we do have to argue this one.
Right.
And Mr. Kaufman's presenting on our behalf.
All right.
Matthew Kaufmann for the Real Water Defendants, Your Honor. Just to kind of hit the high points here. Early in this case, plaintiffs all submitted signed fact sheets in lieu of interrogatories. And in that fact sheet, Mr. Maynard said that he was making a lost wage claim. It's on Mr. Sanchez. Could you pull up Exhibit B of our motion? It's page 57 of the PDF.
Interesting.
We've got it in front of us, Matt.
Okay, sorry, I can't really tell because I'm just got the overview of the court. So this should be Bates number plaintiff fact sheet Maynard G 09. And if you look, it says, did you expect to make any? The question is, are you making a lost earning or lost wage claim? And he lists out his lost wage claim, but in every single one of the answers, plaintiffs note that an expert opinion is needed. We continued through discovery. We took Mr. Maynard's deposition. No expert opinion. Plaintiffs did not produce an expert opinion in relation to Mr. Maynard's claims. And in fact, plaintiffs produced no evidence to support Mr. Maynard's claims other than his deposition testimony until the close of discovery. Then we ended up filing this motion. And we filed this motion because Mr. Maynard is basically arguing here that if not for Real Water, he would have had his contract renewed. And I think that's speculative, Your Honor. And it's speculative for a number of reasons. And I think like plaintiffs, in fact, in their opposition kind of highlighted why this is such a speculative position. You know, they replied, or I'm sorry, they cited to two cases in their opposition, one of which was a case called Tipping Point, and the other one, sorry, just want to make sure I have the right name here. It is oh, I can't find it. Ringo versus Burton. Both of these cases, though, are readily distinguishable from the case at bar, because both of those cases were disputing a pre-existing contract, something that was already in writing, and it was supported by parole evidence from both sides of the contract, which we don't have here, and expert testimony, which we don't have here. Plaintiffs essentially are trying to argue, what Mr. Maynard is trying to do is say, my career would have exploded but for. You know, and in many ways, this is kind of like a collegiate athlete suing his school because he blows out his knee and saying, well, I would have made $30 million in the NFL, but for this. And that's really not the case. And there's no, in order to prove that, you need evidence of an expert. And no expert evidence has been produced. In fact, all the evidence that plaintiffs, almost all the evidence plaintiffs cites to in their opposition was produced after the close of discovery and after this motion was filed. Your Honor, they did not produce Mr. Maynard's previous contract. They did not produce Mr. Maynard's supposed future contract until after discovery had expired in this case, leaving defendants with absolutely no opportunity to respond to any of this. So, I mean, on one hand, I believe this motion should be granted because there's no expert opinion to support Mr. Maynard's claim. And two, I think this motion should be granted because all the evidence they're using to support this is inadmissible at trial because it was produced after the close of discovery and is a 16.1 violation after. And with that, I'll reserve the rest of my time for a rebuttal.
Thank you, sir.
Thank you, Your Honor. I think first I need to start by clearing up some confusion. There's a distinction between lost wages, damages for past lost earnings, and future loss of earning capacity. I would agree in most instances for future lost earning capacity, expert testimony may be required to prove some of those damages. That is why in the question on the fact sheet regarding lost wages and lost earning capacity, the plaintiff objected to the extent it required an expert to provide details. That was related to any potential lost future earning capacity. We evaluated those damages and we are not pursuing lost future earning capacity. We are not arguing that Ray Maynard, but for his real water injury, would have signed a second or a new contract in the future with the UFC. We are not pursuing those damages. All the arguments that Mr. Kaufmann made as if those damages are at issue and why summary judgment is required do not apply to Mr. Maynard's lost wage claim. What Mr. Maynard is claiming is he lost past wages because he was sick from real water, and as a result of that, the UFC terminated his existing contract, just like in the Rangel case. And when you're talking about those types of damages, there is no case law, there is no legal support whatsoever that has been cited to your honor that Mr. Maynard's testimony is insufficient to establish those damages. And the whole basis for their motion is this black letter rule that third-party expert testimony is required for any lost wages claim, whether it's past, future, regardless of facts, regardless of circumstances, regardless if it's in the personal knowledge of the plaintiff or the province of a layperson, and that is simply inaccurate. And we cited multiple cases, case law after case law, in which plaintiffs recovered past wage losses based off nothing other than their testimony. And the reason that's enough is because the jury can hear the testimony, they can evaluate the credibility of the plaintiff's testimony, they can consider it in light of additional evidence on the issue, and they can decide whether the plaintiff has proved their damages. With respect to Mr. Maynard's damages, there is no dispute that he had a UFC contract for 8 fights. There is no dispute that the UFC terminated that contract with 3 fights remaining. There is no dispute that Mr. Maynard would have earned between $50,000 and $100,000 for each of those 3 fights that he lost out on. There is no dispute that Bray's contract was terminated based on his performance in his last loss. The only issue is whether Bray's illness affected his performance. And for the purposes of summary judgment, question before the court is there evidence that Bray's illness affected his performance and was a substantial factor in him losing his contract? And there is, Your Honor. We cited it in the opposition in great detail, starting with Gray's own testimony, which has been repeatedly held by the Nevada Supreme Court as sufficient to support an award of lost wage damages, especially under the uncontested facts that we have in this case. His testimony is not only is it, and all in our opposition, we cite on page 6 that the evidence treatise that says ordinarily in civil cases, the testimony of a single witness is sufficient to establish any fact, including the amount of damages, unless more proof is required by statute, even though the witness is a party or interested in the action. And that's the law in Nevada. It's been repeatedly held in the cases that we cite, including the Ringel v. Burton case, where the testimony of a single witness is sufficient to establish the fact and the amount of damages, even if it's the plaintiff himself. But that's not the only evidence that we cite. We cite numerous additional evidence that corroborates Mr. Maynard's testimony on these damages. We cite the expert testimony of our medical expert, Dr. Hudson, who talks about the physical impact that Gray's illness had on him in the months prior to his fight with the UFC. We cite the testimony and opinions of Dr. Sands, our neuropsychological expert, who testified about the post-traumatic stress and trauma, the mental trauma that affected Gray, which Gray testified to how that affected him in his preparation and his ability to perform in his fight. We show the videos, the public videos of Gray's actual performance in the fight, which was immediately after his illness, and his performance compared to the fight before his performance. There was a substantial difference that the jury can look at and see for themselves and evaluate how the performances were different. And then with respect to the evidence that is cited, there's this blanket statement that, oh, this evidence wasn't properly produced. But first, Your Honor, that is incorrect. All the documents were timely disclosed before the deadline to disclose evidence under NRCP 16.1 A3 for pretrial disclosures. So the question isn't, oh, when was it produced? If that's just the question, it was produced timely. The question becomes, does the disclosure by that deadline cause any prejudice or harm? They haven't made one argument that they've been prejudiced or harmed in any way by the timing of the disclosure of these documents. And the reason they haven't is because they haven't been prejudiced or harmed in any way. In all honesty, we thought that we had sufficient evidence for Mr. Maynard's lost wages, the $150,000 to $300,000 that he was claiming. And this only became an issue when they challenged the evidence. So if they wanted more, we gave them the other evidence that existed, which was all publicly available. This is a professional athlete. His fights that we show the videos of his fights, they're all public record, they're all available. They reviewed it all prior to Mr. Maynard's deposition, and they went off the publicly available information when they were questioning him about his fights, about his career, about the reason for his contract termination. I mean, none of these facts are in dispute. Their only dispute that they raise is this incorrect legal assertion that you need third-party expert for past lost wage damages, which there's no legal support for, and the case law and the legal authority actually demonstrates the opposite, that plaintiffs are perfectly capable of testifying as to their own damages. So at a minimum, there's a question of fact regarding these damages that preclude summary judgment.
Thank you, sir.
All right, whenever, Mr. Sanchez, can you pull up our reply? All right, first I'd like you to go to page 10 of the PDF. And Your Honor, I'm just trying to orient the court right now. This is Exhibit A to our reply. This is plaintiff's 25th supplemental initial disclosures of documents and witnesses pursuant to NRCP 16.1. Now I'm going to ask you to go to page 169,
No, we're not
please,
there.
Mr.
Matt, we're not there.
Oh, I'm sorry.
What page?
Go to page, hang on.
We didn't get the first one.
Okay, so the first page was page number, hang on. Page 10 of the PDF.
Page 10 of the real water reply. I know you can't see the screen and
Yes,
Yep.
page 10 of the reply. It should be plaintiff's 25th supplement, the first page of plaintiff's 25th 16.1 disclosures.
yeah, that's page 10 of the disclosure. Can you go to page 1 of the disclosure?
What?
Of the disclosure. That's not plaintiff's disclosure. Hang on, Matt, we're having a technical issue.
No problem.
All right, now we have the 25th supplement in front of us, Matt, sorry.
Great. Whenever, are you ready, Your Honor?
Yes, I am.
Okay, so this is plaintiff's 25th supplemental initial disclosure of documents pursuant to that 16.1. Mr. Sanchez, could we jump to page 177 of that PDF, or I'm sorry, 178 of that PDF?
We're there.
Okay, and what I want you to note here, Your Honor, is this is dated September 9th of 2024. This is the disclosure of discovery in this case was October 23rd, 2024. And now can we jump to page 1? $141.
We're there.
Okay, now page 141, Your Honor, if you notice, there's several, this is documents produced by plaintiff's counsel on behalf of Graham Maynard. The documents in bold are new productions. They include the video of the fight, stills from the video of the fight, and all this other stuff. And you notice the contract is not listed on here, Your Honor. The contract wasn't produced until after discovery closes. So I think the fact that what the contract says is not relevant. And the reason I really didn't get to prejudice is because I didn't think we had to go there. Because the plaintiff had produced evidence after the close of discovery. And I thought the prejudice was clear in that, plaintiff had 2 years to produce the contract to the fund, to produce the termination letter, and nothing was done. It was not done until after we filed the motion. And I don't think that's in keeping with the spirit or the letter of the law. And as to plaintiff's argument that this is all about past wages, one, we have a couple of problems. Graham Maynard just saying I would have won that fight is probably not enough. And I think an expert opinion is needed, even just to argue that he won that fight. I think I should have won a couple of trials that I tried, but that's not how it worked out. And I don't think me saying it should have worked out differently is dispositive of anything. At the end of the day, Your Honor, all the evidence they're using to counteract this was produced after the fact. It shouldn't be admitted at trial, and therefore the plaintiffs have no evidence to base this on. Because at the end of the day, this was about it wasn't about something a job he had that he lost. It was just about him not getting a new contract. And I think that is something different and would require an expert opinion. And with that, all of us. Thank you, Your Honor.
Oh, you're welcome, sir. I just have a couple comments. What I'm going to do before I make a decision on this one, I want to read Ringel versus Burton, which makes a lot of sense. Secondly, I just have a couple of this general comments. Because sometimes I really have two. Number one, when it comes to potentially late disclosures, ultimately, the rules aren't self-executing. And what I mean by that is, if you miss the deadline, that doesn't stand for the proposition that there's automatically a bar. There's been no discussion as to specifically what the standard should be. For example, do I follow Rule 16? Is it a good cause standard? Or do I follow Rule 37 and do I have to conduct a substantial justification and or harmless type analysis? I think that's really important. In fact, you can go read Moore's Federal Practice and Procedure, and that's one of the things they talk about it specifically as it pertains to Rule 37. It's not self-executing. And so that's just a general comment. Now, I do understand the defense position in this case, and that's why I have to read Ringel and see exactly what was going on there. Because traditionally, we do, when it comes to, for example, future medical care, and we all know what the standard is, you have to have an expert, future wage loss, you have to have a medical expert come in traditionally and testify on that issue. However, even under those circumstances, potentially there might not be a hard, fast rule. I'll give you an example, and I don't mind taking deep dives. I do that from time to time. I think 2 or 3 trials ago, an issue came up regarding medical charges and whether they have to be, the expert has to testify to whether they were reasonable and customary in the community, right? We did a deep dive, and it's my recollection, we didn't find anything about a case that talked about customary in the community. And here's my point, that probably came from the old standard of care issues regarding locality versus a national standard. That's kind of where I think that came from, because I thought about it. Bottom line is that medical charges have to be reasonable. That's what all the case law says. And so all I'm saying is this, I want to read Ringel, and I think there's one other case that was cited too, Cresser. I want to read both those cases just to make sure I have some background, and I want to see specifically what the court in Ringel discussed. I do realize they're cited, but I haven't read the cases, and I'll read cases. That's what I want to do.
Thank you, Robert.
Thank you, Your Honor.
You're welcome, sir. So
Next
before
will be,
you go, I just want to make a note to myself. Or it will get lost. Okay, man, I'm ready. Yeah, I can give this. Yes. You can give it to Alex. Thank you, ma'am.
and then next will be docket number 563, plaintiff's motion for summary judgment number 2.
So-
Move.
That one, I believe, is moot, Your Honor. Because it dealt squarely with Terrible's motion.
And they're out of the case.
And they're out of the case. That's correct.
Okay, move.